Justice Watchers, before we begin, I want to make this absolutely clear. The following broadcast contains public domain courtroom footage, commentary, and legal analysis. This content is presented under the Fair Use Doctrine as defined by 17 U.S.C. 107 and is protected by multiple Supreme Court rulings, which you see below. This stream is transformative, educational, and journalistic in nature. It includes original commentary, trial breakdowns, legal interpretation, and critical analysis, not raw redistribution. We do not claim ownership over any public domain footage, and all use is strictly within legal bounds. If you're watching this content, you're engaging in a protected, transformative experience, grounded in law, never in speculation. And if anyone has a problem with that, take it up with Campbell, Brady, Miranda, and Irvin. Remember, guys, justice always works better when we watch. So keep watching. See you in the courtroom.
Hey, remember that transcript that we sent us, actually forwarded the attorneys? Do you have that and can you forward it to me? Because I can't follow it. Hmm? got it? Appreciate it, thanks. See you. All right, let's go on the record. My understanding is the jury's reached a decision.
Yes.
All right, anything we need to discuss before we bring the jury in?
No, Your Honor.
All right. Bring 'em.
All rise. Jury's in order.
It's only somebody will ask you. Which one do you want? Probably the second one. So basically, this, I'll read this, and then, I'll ask you who it is. I'm just calling it reflected by the numbers. All right, ladies and gentlemen, y'all may be seated, I'm sorry. Sneaking up on that. So I understand you all have reached a verdict.
Yes, sir.
And if the foreperson could hand that to our bailiff. Publish the verdict to the jury.
State of Florida versus Ronny Tremel Walker, case number 22CF009001. We, the jury, find as follows as to Ronny Walker in this case. Aggravating factors as to count one. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that Ronny Walker was previously convicted of a felony involving the use or threat of violence to another person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder was cold, calculated, and premeditated without pretense of moral or legal justification. Yes. Sufficiency of the aggravating factors as to count one. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, Section A, we, the jury, unanimously find that the aggravating factor are sufficient to warrant a possible sentence of death. Yes. Mitigating circumstances. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. Eligibility for the death penalty for count one. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt, Section A, outweigh the mitigating circumstances established, Section C, above, as to count one. Yes. Jury verdict as to death penalty. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, Section A, that the aggravating factors are sufficient to warrant a sentence of death, Section B, and the aggravating factors outweigh the mitigating circumstances, Section D. We, the jury, unanimously find that Ronny Walker should be sentenced to death. No. If your vote to impose death is less than unanimous, the trial court shall impose a sentence of life without the possibility of parole. Dated this 27th day of June, 2025, in Hillsborough County, Florida.
You may be seated. Anything else? The attorneys could approach for a minute. All right, ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges that are enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room. except by court order. For many centuries, our society has relied upon juries for consideration of some very difficult cases, this being an example of one of the most difficult. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affairs so long as they shall wish it. Therefore, the law gives you the unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone if you wish. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether you wish to preserve your privacy as a juror. And again, on behalf of everyone here, we want to thank you for your service during this time. And I now discharge you from your service.
All rise. Don't forget all your personals.
Can I see the verdict form? Jury's left, y'all may be seated. Any reason why I should not pronounce sentence at this time?
No, Your Honor.
All right. Mr. Walker, the jury finding that the aggravated factors to count one was yes, and it was established beyond a reasonable doubt, yes. Sufficiency of aggravating factors is to count one, yes. Found mitigating circumstances, yes. They found that you were eligible for the death penalty for count yes. The jury decided to show mercy in this case and return a verdict of no as to entering the death penalty. Therefore, I will now adjudicate you guilty and sentence you to a term of life in prison without the possibility of parole. Any court costs and costs of investigation, I will convert to a lien.
Can I get you the credit?
Any credit that he's got, even though it's irrelevant, will be entitled to any credit. But he will be remanded to the Florida State penal system until such time as he doesn't have any more time left.
Your daughter, man. Your daughter, babe. Snowing at the moment. Sorry, what happened?
You should have got the death. That's what you should have got.
Thank you, your baby.
That's what you should have got.
So,
You're
Your
a killer.
Honor,
You're a natural born killer. You've been killing for a long time. You just got caught up this time.
so, Your Honor, the state would be asking for the prosecutor's cost in this case. I
The
think we
cost?
have to- The cost of prosecution. It's-
Or
we
the
have to
cost of
ask
prosecution,
for
I'll convert that to a lien as well.
it. Okay, thank you.
Does that mean?
It takes like last week.
Yeah. Well, anyway, so before you leave, just real quick, I'm going to set this off for a disposition in about 3 or 4 weeks. So that if you want to discuss the resolution of the PRR issue as well as the new charge, you can discuss that with your attorneys. All right? Thank you, folks. That would be count two. So that was.
Don't say that.
Oh, not guilty.
Tampering.
Yeah.
Tampering charge.
Yes.
Tampering charge, count two.
He was already found guilty.
I think it needs to be sentenced.
Oh, yeah. I'll give him time served on the tampering charge.
Just for the record, Mr. Walker's credit is 1,087.
You're gonna do it.
1,087 days.
Thank you.
Let me see if I can find a date somewhere down the road just for disposition. 5 August. We'll do it. August 18th at 8:30.
I'm sorry.
August 18th at 8:30 for disposition. And if we don't resolve it, we'll set it for a trial date at that point.
Thank you, Your Honor. Do you want me to strike all days?
What's that?
Can I strike all days?
Okay.